Good morning, Inspector. Just to say you are live on YouTube.
Good morning. Can everyone hear me?
Yes, we can, sir.
Yeah, good. Is everyone here? Yes, I can see the main parties are here. So the inquiry is resumed. And just to say a few things, just to remind people about the procedure, those who are taking part, they can have the video on, and if you're speaking, unmute yourself. Otherwise, everyone else should be muted and have their video off. Few points regarding matters that have arisen. There's a statement from Mr. Poole, who said he would make a statement, which has now been provided to me and hopefully to other parties. Have you seen that statement? Which is just confirming what he considers his response to the inquiry itself. And thank you, Mr. Poole, for providing that in good time, and so that's been helpful. Thank you. And on other matters to do with other information that I'm expecting, is that available?
Are you talking about the 106, sir?
And a SIL compliance as well, I need.
Oh, SIL compliance. Well, can I give you an update on matters which? Well, shall I let Mr. Howell Williams go first? As that one's in his part.
Yes. Thank you very much, sir. So in relation to the 106 and the associated SIL compliance statement, I'm afraid we're not as far advanced as both parties would have hoped. And I think it's fair to say that there are two areas of difficulty. The first is in relation to the community and sports facilities and the question of governance. I don't want to go into any details, but I think very recently, perhaps even yesterday, the appellant indicated what it would think would be appropriate as a pre-commencement term, and my client is considering that. I don't want to say anything more about that without further instructions, but it is an obstacle in the discussions at the moment. I think that's fair to say. The second category, sir, is there are a number of detailed matters which have not been sufficiently refined to pass on to you, and a matter that Mr. White is going to ask you about affects those detailed points on the section 106, which the council is considering, and I leave him to come back on that. And of course, in relation to the SIL statement, they do to some extent go hand in hand. So I hope that gives you a fair understanding of where we are on that. So the only other outstanding matter which I have sought to chase, indeed tried again yesterday, related to the question of the figure of, I think it was 222 in the housing roundtable session, where you indicated that some more clarification might be helpful. Do you remember that?
Yes.
Question, and I indicated that I would take instructions on that, and Mr. White quite properly said, well, he would reserve his position. Sadly, because of where we are in the week and the half term, the relevant person who's in charge of the calculation has not been available. It is possible that notwithstanding that she is on leave, that we will be able to provide a statement, a short clarification statement today. But I fear it may not happen, and in which case it will have to be sent to the programme officer for your attention, and importantly to the appellant on Monday, to be sure that insofar as Mr. Taylor wishes to make any response, presumably in writing, then he can do so.
Yeah.
I think those are the matters by way of update, unless I can help you any further.
Right, thank you, Mr. Howell-Williams. Mr. White?
So I agree with what Mr. Howell-Williams says about the 106. Obviously, we will try and do everything possible to narrow what lies between us. In relation to his point about the HLS clarification note, it's just one of those things, and I agree with his course of action. Once it emerges, I will ask Mr. Taylor if there's anything he wants to add in writing. I don't believe it would be necessary or benefit you to call him back. So let's just do that in writing. Could I raise another couple of points, please? We obviously have noticed over the course of the inquiry the concern that you've expressed about the 141 and the master plan. Indeed, you picked me up understandably in my cross-examination yesterday. In order to assist, the appellant is willing and to amend the description of the development to up to 141, and also accept a condition making it clear in terms that there shall not be more than 141 units on the site. And we'll obviously seek to agree the wording of that condition with the council.
Yeah, right,
So,
thank you.
So yeah, I think we would ask you, I am making the formal request for you to amend the description of development that you grant to that up to 141. So that, and the same, obviously, as I said, will come forward in the condition session. Well, we'll hopefully agree the words with the local authority.
Right, thank you. I'll just seek the views of Mr. Howell-Williams on that. I don't know whether he was aware of that being put forward, but Mr. Howell-Williams.
Yes, aware. I had noticed late yesterday, and I have, though, had the opportunity to take instructions, and the council is content with the proposed amendment and does not object to the request now formally made by Mr. White in relation to the description, and similarly to seek to agree a form of words for the purposes of the condition to which he refers.
Yeah, can I just ask, in terms of the section 106, does that make much difference to that? And also in terms of the level of affordable housing, because there's 4 less houses going to be provided as on the site. So
yes, well, so that I was about to add that rider, as it were, that we are checking the section 106, but unless I get back to you, sir, we don't contemplate that should alter the council's position in relation to the proposed amendment. But as I indicated earlier this morning, there will be changes to the section 106, and there will be implications as a result of those changes, and we reserve our position in relation to comments to be made on those matters, as well as any other matters arising from the scheme's change.
Yes, I mean, I mean, hopefully I haven't really looked at the section 106 in any great detail because I haven't been given anything, but But in terms of section 106, I would assume that it's been written in such a way because to allow for variations in numbers of dwellings, because even though the description is going to be amended, it was up to 145, and so that means it could have been less anyway. But obviously I can see that as the scheme that's been put forward on the master plan is 141, and I haven't got a scheme that shows 145, so I can understand why 141 would be the maximum that would be suggested. But hopefully the section 106 allows for that anyway. But
well, so we're hopeful, but I'm sure you'll appreciate why I need to reserve the council's position. But subject to any problem arising on the 106, and I hope it's acceptable to put it in this way, we would not object to the proposed amendment.
Right, thank you.
And so can I give you comfort that, as I understand it, I mean, obviously Mr. Hal Williams has indicated his solicitor and he will look at this, and I can assure you that our solicitor's also looking at the 106 in the light of what I've just said. So hopefully it's not beyond our mutual abilities to identify in what way the 106 needs to be changed and make the changes accordingly. But we're well aware of the point.
Right, thank you. The other matter that I'd like to, well, there's going to be a timetable. We're going to discuss. I'd like to discuss that at the end of the day to see how we're going to maybe revise the timetable if necessary. And also the other matter is the site visit. I have been requested about asking about timing of the site visit, but I won't be looking at that, the date or time of the site visit, until I know when I've heard all the evidence. And I certainly won't want to carry out the site visit until I've heard the evidence. But at the moment, it's looking as though I might be able to do it earlier, but we'll have to discuss that. And I just want to remind people that there seems to be a number of people may want to accompany me and the other parties on the site visit. But I'd like to say that it won't, there's not really a way of anyone who accompanies me putting any points forward at the site visit. So it's not particularly necessary for anyone else to come on the site visit, as long as the points, the places and views or whatever that people want me to see are just highlighted on the itinerary. So I can't see that there's any benefit in a lot of people accompanying me on the site visit. However, I'm expecting at least one person from I would assume that one person from the council and one person from the appellant would accompany me at least. And I'm happy to have someone representing maybe the town council or one of, really the town council is probably the most appropriate, but I'm happy for one person to represent the third parties on the site visit. But I prefer not to have any more people on that. Otherwise, it just becomes unwieldy. And like I say, we will be going on. Well, it might be quite a long site because I haven't seen the itinerary, but there'll be quite a few places to visit, I would imagine. And some of the terrain might be a bit awkward. I don't know. But so I prefer not to have too many people coming along. Having said that, if it's on a public footpath, I can't prevent anyone going along anyway. But on the actual site visit, we may stray off the public footpath to see certain aspects of the scheme and areas. So, but I'm not sure what other. There might be a chance for, say, Mr. Poole to just point out his concerns at the appropriate site which is around his property as well. But like I say, I don't want too many people on this site visit. So I just want to say that. And I will be trying to arrange that at the end of the proceedings today. So
Okay.
anything else anyone would like to raise?
Yes, could I just say, so Mr. Howell Williams and I have had a conversation about timetable. Can I just say from the appellant's point of view, and I just float this up for you to consider, we think probably rather than shift the timetable, could we, if we do complete Mr. Ross today, could we have Tuesday as a day when the inquiry doesn't sit, and then we keep to the as programmed timetable, like Wednesday 106 conditions, Thursday the site visit, and then Friday closings? Because frankly, it suits the appellants to keep to that timetable rather than bring things forward. And I think various arrangements have also been made for Thursday. So I just float that would be our preferred way forward for you to consider today to keep the timetable. Could I make one other point which does affect the timetable? And I'm remiss not to raise this with Mr. Howell Williams, but I now do so. And he doesn't need to look concerned, but I'm going to confirm, subject to no applications from the council, there will be no applications at the close of the inquiry from the appellants. So that just obviously impacts the timetable, and it also saves Mr. Howell Williams having to ask any potential issues that relate to any such applications if he was minded to do so with Mr. Ross. There will be no applications from the appellant, subject to knowing that Mr. Howell Williams is taking the same approach.
Right, thank you very much. No, that was helpful, because I like I say, I was going to try and review the timetable anyway. I must admit it may be helpful anyway, bearing in mind that there might be might need a bit of extra time to get the documents ready anyway for the section 106 and conditions.
Well, I didn't
so it might be helpful to have that extra day if we do have an extra, which I think we probably will have an extra day.
You've spotted the point, sir. From our perspective, as Mr. Howell Williams has said, there is still some discussions to be had on the 106, and to not have anyone tied up with the inquiry on the Tuesday can only assist the process of trying to get agreement if possible.
But anyway, I'll hear from Mr. Howell Williams whether he's got anything to add to that. He's got his hand up. So
yes, thank you very much, sir. On the two matters raised by Mr. White, so I'm not instructed to make an application for costs, so we are at one on that. So neither party wishes to trouble you on that matter. So far as the programme is concerned, I wholeheartedly agree with both Mr. White and yourself, sir, that it seems really sensible, actually, to keep Tuesday free for further work, and because of commitments that people have already made for next week.
Right, so that's in agreement then. So really we're effectively sticking to the programme, albeit that we might well I would hope that we'll probably hear the whole of Mr. Ross's evidence today. That's what I'm intending. I'd just like to say, is there anything else that anyone wants to raise at this point?
Well, so can I just raise one thing, which I don't know if it's got through to you, but I think there's a member of the public who wishes to ask Mr. Ross some questions. Has that got through to you from the programme?
I didn't know that, but it hasn't. Well, I might have just received it. I'll just have a look.
Yeah.
Oh no, I've got is a formal amendment, a formal request that the description of the development be amended. That's all I've got. I haven't got anyone. Has anyone got an idea of who it is?
Yes.
It's a member of, sorry.
Yes. So the lady in question is a Samantha Reed, and she has got a list of questions from Mr. Ross.
Right. And I think Miss Reed has, I mean, I know Miss Reed didn't put a statement in, but I think she is representing, is that right? She was,
Limes, I think the Limes Land Protection Group,
yes,
so she
yeah, she was putting in information to do with Limes Land Protection Group. So she's representing that.
So can I say I have no objection. The only thing I will say is some of the points are quite detailed in relation to specific subjects. Like I noticed landscape is raised, ecology is raised, etc. I mean, yeah. I mean, Mr. Ross will do his best, but some of these questions, frankly, yeah. Well, why don't we let her ask questions? Mr. Ross will have sight of it, and he can deal with, and those he can't deal with, he'll just have to say, frankly.
Yes, yes, I'm happy to do it that way. Yes.
Good.
I mean, it is a bit unfortunate that these questions weren't asked to the appropriate witnesses when they were available, but certainly I haven't had a look at those. I haven't seen those questions, but certainly that would be, if you're willing to try and address those with your witness, that you've got your remaining witness, then if that's, but like I say, I prefer not to be in a position to recall or you to recall any other witnesses that we've already heard. I don't want to go over the whole evidence again that we've heard.
Well,
so
I share that.
So with that proviso, I'm happy for you. Well, as you've already seen the questions, you might be able to, in evidence in chief, just deal with some of those matters perhaps briefly as you go through it. But anyway, we'll just see how we get on. And so what is there, unless there's anything else, is there anything else anyone's wishes to raise? So in that case, Mr. White, if you can call your final witness. Right, thank you.
Thank you very much, sir. Can I call, as you say, the appellant's final witness, Mr. Ross? And I think to assist you, could you please take up Mr. Ross's proof and appendices?
Yes, I've got those, yes.
Wonderful. Now, Mr. Ross, could I introduce you to the inquiry, please? And we will go to 1.1 of your proof. You're a chartered member of the RTPI.
That is correct.
You have an honours degree in town and country planning from UCL.
That is correct.
You also have a master's degree in land economy from the University of Cambridge.
That is correct as well.
And you've worked as a town planner in both public and private sector for nearly 20 years.
So it appears.
You've been a planning director at the appellants since June 2021.
That is correct.
You've also been a planning director at JLL, which the inspector will know is a firm of agents since May 2019, and you're retained still as a consultant by JLL.
That is correct. It's in relation to some cases that remained while I was there, and I'm just still addressing those.
Great. And you also are, you were prior to that a director at JL Hearn, and prior to that you were head of office at Boyer in Twickenham.
Yes, that is correct.
You also worked in local authorities, one of which was the London Borough of Enfield, where you spent 1.5 years as their head of planning enforcement.
Yeah, 3.5 years overall and 1.5 years as planning enforcement. Yes, that's correct.
And then you set out your experience at giving evidence, which is in your Appendix A, and some of the schemes you've been involved in. And just for the inspector to note as we went, it's an inquiry document, is when you refer in your appendices to 250 homes near West Malling, that is also what's also referred to as the Leybourne decision. As you will recall, Mr. Ross, that site is one of those unfortunate sites in the sense that it falls within an area that some people say is West Malling or East Malling, Leybourne, etc., etc. And you'll remember that debate. You also set out the public inquiries you did and the EIPs you've done. And you've obviously been involved in this matter since. When were you instructed in this matter, please?
So it was August 2021 is when I started getting involved. I've known about this site because I've been doing work for Waits as a consultant for probably around 7 years or so, probably since 2015 when I was working at Boyer, and have appeared for them in various cases. And I kind of know what's going on, and discussions always were going on about, you know, the Tenterden site and what's going on in terms of the applications and the process. So I've been well aware of the site for quite some time, but excuse me, around August 2021, when the application was going towards determination, I started getting involved in the discussions in relation to the application and its process. And that's when there was a consideration as to if the application was to go to appeal, whether I would be able to assist and give the planning evidence on behalf of Waits.
And also, can you just say, in relation to a passage when I asked Miss Goodyear about this, what is your experience in Kent?
Well, I've got significant experience in Kent, as you set out the Leybourne decision, which was last year. That's in Tonbridge and Morling, and that is an inquiry in Kent. I've done many site promotions in Kent, and I've done sites in Asheville as well, including town centre sites, and recently advised on 2 greenfield sites in the periphery of Asheville as well.
Thank you. And did you also, in the light of Leybourne, you appeared at the EIP in October 2020?
That is correct. We had 3 days of examination in public at Tonbridge and Morling, examination in public before the plan was found unsound by the local plan inspectors.
In accordance or in contravention of the point you were making in evidence at that EIP?
No, the inspectors totally accepted the points that we were making. Soundness.
Right. Now, I want to ask you, in substance, please, I've got 8 matters I want to ask you about. And the first one is, I just want you've obviously had the benefit of hearing all the evidence, and particularly Miss Goodyear's yesterday. I just want to ask you to set out what you consider is the correct planning context to consider the application, please.
I think it's agreement between all of us that the starting point for the inspector in considering the application is section 38.6 of the Town and Country Planning Act, which sets out that decision should be made in accordance with the development plan unless material considerations indicate otherwise. And I think it's also agreed between us, and I don't think this is controversial, that the NPPF is a significant material consideration. And that the paragraph 11D, the operation of the presumption in favour of sustainable development, is an important consideration for the inspector when he is considering the determination of this application. And again, it's not between us and the local authority that paragraph 11D is engaged, because the council on their own evidence wholly accept that there is no 5-year housing land supply, and on their best case scenario there is 4.54 years of housing land supply, and that has several implications to my mind. And I do have a question, in terms of, to my mind, as to when the local authority would have a 5-year housing land supply. And I think that is material, and I'll probably perhaps touch on that a bit later during my evidence. But the point of 11D and why the government have introduced this has to be set out in the context of the government's wish to boost the supply of housing and to meet this overall requirement of 300,000 homes per annum, which continues to be the government aspiration. The government has not moved away from that. And that is why the tilted balance was introduced. And it has to have an impact on the operation of the balance that the inspector has to undertake. It simply would be, if the council's approach is correct, the tilted balance would be irrelevant. You know, that a local authority does not have a housing land supply would be irrelevant in the overall balance. So if you look at paragraph 11D, it has two implications. One, obviously, it automatically introduces a tilted balance, and therefore 11D2 is correct. We don't know, nobody is alleging that 11D1 is applicable in terms of policies disapplying it. So the test is significant demonstrable harm needs to outweigh the benefits. But 11D also sets out that the most important policies have to be out of date. And that has to, again, mean something. If the policies are not out of date, and if you continue to give those policies which lead to the failure of having a 5-year housing land supply, continue to give them full weight, you will continue to have that failure. Basically, there will be no way of overcoming and addressing the issue that you have in terms of the local plan failure. And I think that, you know, that is really important. That there must be some manifestation in the overall weight afforded to policies by the lack of a 5-year housing land supply. If you continue to just say that all local plan policies have full weight, I simply don't see how you can comply with this key notion that the government have introduced in terms of the presumption in favour of sustainable development. So I think that's, Mr. White, I think that's an important context to set out initially.
Right. So I was trying to be good and muting myself while you spoke. Second matter, I put various matters of agreement to Miss Goodyear, which were largely accepted. I just want, again, you to summarise those matters that you think are pertinent and not in dispute between the LPA and the appellants at this stage of the inquiry, please.
Yes, of course. Well, I mean, I'm not going to go through the whole list because, you know, those are matters agreed, and the inspector's got an agreed statement of common ground, both in terms of overarching, but also in terms of the individual areas. And, you know, I'm not going to go there. But I think what is important is to be clear that there are no designations relation to the site other than a small part of the conservation area on the western boundary, and there's no allegation of harm to that conservation area. I think that is quite important. And I will address, I've read Miss Reed's notes about her comments that the site is within a landscape character area. Well, yes, every parcel of land in the country is a landscape character area. That's not a specific designation. And therefore that isn't a matter. I think it's also correct, and clearly I'm going to put a rider on this to satisfy Mr. Howell-Williams in relation to the change in the council's case since the reason for refusal. So when we had the reasons for refusal, we had 9 reasons for refusal alleged that were alleged to be breached by this development. And clearly, one of those in relation to flooding, a reason for refusal 7, has been removed by the council, and 2 of the trees in reason for refusal 4, tree 312 and 313, have also been removed by the council. So I think there is a shift in the overall planning balance from when the decision notice was issued. There's a shift towards the appellant, and clearly if there is agreement in relation to the site section 106, and again I put the ride on that, if there is, I would be hopeful that there is, but clearly that will be a matter for discussions next week. That would be another reason for removal removed. And I've obviously heard all the evidence, and I think Miss Goodyear as well yesterday. I think, you know, she fairly accepted that reason for refusal late, that's in relation to the AB 70, was not supported by policy TRA 5. I think that, you know, on the reading of the policy, I think that's the correct reading. So again, that reason that policy is not breached by granting consent. And I think 2 other points that Ms. Goodyear agreed yesterday. I think one, she agreed that in terms of affordable housing delivery, and again we'll speak a bit more about affordable housing delivery in Ashford, but I think she accepted that overall the performance was poor. I think those were that was her word and her wording. And if I've got the wrong notes, Mr. Howell Williams, I'm sure will correct me. And I also
do you know lamentable?
Sorry.
Do you know what lamentable is?
I do know what the word lamentable is, and I would have accepted the word lamentable in relation to the affordable housing delivery. It is extremely poor, but you know, if that's what Miss Goodyear has agreed, that's her view, and I'm not going to challenge her on that. But I think poor is poor. And then in relation to the shortfall, the 664 units, that on the council's case, clearly, so as you know, we don't agree, and we think that on the evidence before you will clearly come to a view that the housing land supply position is significantly worse than what the council's position is. But even on the council's case, 664 units, I think she agreed that the shortfall is significant. I think my view would be, if you agree with us, that either on scenario 1 or scenario 2 of Mr. Taylor's evidence that the shortfall would be regarded as more than significant, it probably would be severe. And only 2 other comments in terms of context and agree matters. And you have before you, and you've been taken to these previously, the previous appeal decisions from 1989. I think that's CD 6.1. We don't need to go there, so I think you've been taken there many times. And I think it's agreed that the context of that appeal, what it covered, its entire proposal was just for housing and not a country park, and all other matters, and clearly a very different policy consideration. But I'm not saying to you, sir, that you should disregard what the inspector said there. Clearly, what the inspector said in relation to his comments about the site of valid comments, you know, they were the view of the inspector at the time in 1989. But clearly, you've got evidence before you, and you know, you will come to your own view in relation to whether the inspector was right or whether the evidence supports a different view. And I think the same is said in relation to the inspector's report in relation to the Tenterden and rural sites development plan document, and that's CD 6.2, sir. Sorry, 2.6 for your reference. I don't know if we've gone there, sir, and I don't know if you do want to go there, but it's all set out in evidence. And the inspector, that was when the Ashford borough was divided into 2 housing market areas, where you had Ashford and then you had the Tenterden and rural areas. It was a separate document. And that in fact is the document that originally allocates Tent 1. And that's why it's called Tent 1. So that's back in 2010, sir. And you'll see that allocates the whole of Tent 1, so not just Tent 1A, but Tent 1B. And I'll talk a bit more about that at a later stage. But it's considered this site as well. And you'll see comments. And I think Mr. Smith was taken to the views made by the inspector there in relation to the site. And again, I don't say to you, you cannot take the views of the inspector into account. Clearly, that was a view taken at the time. But when you do that, sir, I do urge you to look at what the inspector says about Tenterden and other sites, because if you continue reading after where this site is considered, you will get in paragraph, this site is in 2.98. If I remember, and then if you turn over the page, you'll see 2.100 is where Tilden Gill is considered, and the inspector also talks about the rural nature of that and the impact that development there would have on the countryside. And as you are aware, in 2016, on appeal, planning permission was granted for the development of Tilton Gate. So I think that in a way, reflects a process that was undertaken at a time. And when the proposal was then considered at a Section 78 appeal, the inspector came to a different view to that set out by the inspector considering the development plan document. And I would urge you to say that that clearly is open to you to come to a different view to those inspectors based on the evidence that you have before you.
I think, Ross, the reference is to paragraph 2.100.
Yes, that's what I said. So 2.98 relates to
the earlier one.
land north of Appledore Road, which is this site. Although clearly significant differences there. You can see, sir, that if you go back and you can see what the inspector was considering, the proposal was 200 to 300 homes. And clearly that 300 homes is significantly different to what is being proposed here at 141. But the point that I make, sir, is that the inspector there considered that Tilton Gill should not be allocated because of the impact on the rural character and nature, yet only 6 years later, a different inspector under Section 78 appeal considered that the site should be granted consent for 100 homes.
Thank you. Right, next issue, please. Can we grapple with, can I ask you to give your evidence in the light of the position put by the council and Ms. Goodyear yesterday? Can I ask you to grapple with SP1, SP2 and the question of what the development plan says or doesn't say about distribution and the strategy? Could you tell the inspector your view on what you say is the correct approach to distribution in the development plan, please?
Okay, well, let's say, if I may, and I think it's important to go to the policy. So if you could bring up the local plan, and I want to start with SB1, if at all possible, sir. And in fact, can I first go to the vision, because I think Miss Goodyear was taken to the vision, and I think it's fair that I probably do the same approach in terms of the vision. So, sir, that is on page 8 of the local plan, and as we can see, so it starts off with Ashford Borough will meet its housing and employment needs, take account of need of investors, provision high quality development, attractive places, necessary supporting infrastructure services, sustainable and accessible locations that take account of the borough's environmental constraints. Now, there's nothing in that. That's obviously addressing the whole of the borough, and the test there is whether any locations where you're looking to put any type of development, it's not just relating to housing, obviously it's employment needs as well, need to be sustainable and accessible. I think that is important when you consider your decision as to whether the site is sustainable and accessible. And then the next paragraph, the town of Asheville will continue to be the main focus for development with the regeneration of town centre and areas where existing environmental and social issues and vibrant new communities on the periphery of the town. I don't disagree with that. That's correct. It should be the main focus, but it's not the only focus. I think it's the main focus. When we go in to look at SP2, I'll make a comment as how this vision is manifested itself in the policies itself. And then fourth paragraph relates specifically to Tenterden, sir. And I think that obviously is the most important part of the vision in relation to us. It says Tenterden will continue to serve the southwestern part of the borough, principal rural service centre, strong offer of shops and services, conserving and enhancing its historic centre, and accommodating development of suitable scale, design and character. And to my mind, this is a positive element of the vision. It is setting out that Tenterden should accommodate development. Question as to whether it's suitable scale, design and character, but it is not saying there's any restriction in principle of development. it simply doesn't exist. The matters of whether it's appropriate in terms of scale, design, and character will be a matter for your judgment, sir. I don't think that I want to really go to any other element of the vision. So I think if we turn to policy SB1, and this is the strategic objectives, and obviously as it's set out, sir, the first part of that in the preamble, or the beginning of the first sentence of the policy, it says to deliver the vision. A number of strategic objectives have been identified. They form the basis of the local plan policy framework, as well as providing the core principles that planning applications are expected to adhere to. So these aren't development management policies set out here in this, and you wouldn't expect that. These are strategic objectives. But it's clear that when you are determining planning applications and for your decision-taking purpose, you have to have regard to these principles. And if we move to A, what A says is to focus development at accessible and sustainable locations which utilize existing infrastructure, facilities and services wherever possible, and makes best use of suitable brownfield opportunities. So this policy only requires, or this principle requires, to focus development at accessible and sustainable locations. And again, that is the test for you, sir. Do you consider, based on the evidence, that the development site is an accessible and sustainable location? It doesn't say more than that. It doesn't say they need to be delivered in Ashford. You can have an accessible, sustainable location next to a small settlement. Absolutely, you can, and that will not be breaching this. But it's not only that; it's got a caveat, sir. It says wherever possible. It doesn't say even when it does say this. That's not an imperative. It's not a you must put development only at accessible and sustainable locations. It's wherever possible. And clearly our evidence, and I think the council in fact accept that the site is accessible and sustainable. We might have a question between us as to whether it's highly sustainable or relatively sustainable, but I don't think that there's an allegation from the council that the site is not sustainable. I don't think there's an allegation from the council that Tenterden is not sustainable, given that it is the second most sustainable settlement in Ashford Borough, and that's agreed in the Statement of Common Ground. And then just tried to deal with distribution of housing. I can't see anywhere else in policy SP1 that deals with distribution of housing, i.e. the overall distribution of housing. When you look at it, B is talking about natural environment, C is heritage assets, D is design, E is to do with infrastructure, F is to do with access to wide choice of sustainable transport, that's not to do with distribution, then mix with employment and resilience in terms of climate change. So when you're looking at what the policy exactly says, and it's important to read the policy because that is what you're judging against, there is nothing in policy SB1 that says that you have to provide development in Ashford or that you can't put development in Tenterden. All it requires you to come to a judgment is whether the site is accessible and sustainable. And I think that even on the council's case, policy SB1 is adhered to by this proposal in relation to distribution of housing. I accept that there's other matters, and we'll go to those in terms of other points, but I do want to address distribution of housing at the moment. Now, say if we move to SB2, if I may, and I'm not going to deal, Mr. White, now with whether it's up to date or out of date. I just want to, because the requirement says whether it complies with the development plan, and then we deal with material considerations afterwards. So, let's see whether there is a breach of SB2. in relation to this proposal. And the first sentence is this housing target of 13,180. And that's the requirement. And that, to my mind, that requirement is up to date, sir. That is the figure set out in the local plan, and that figure will only be out of date 5 years after the adoption of the plan, as required by the NPPF, when you start moving to using the standard methodology. Whether that can be achieved, sir, is a totally and utterly different point. I will set out that 13,118 simply cannot be achieved at all, and on the council's evidence. But that is the figure that they're aiming to achieve. And if you take that in those 12 years and you divide 13,118, it comes out to, I think, 1,093. So that's the figure that the council are seeking, need as a minimum to deliver every year. And you've got the figures before you, sir, in terms of the delivery of this authority since 2018. And in no year, 2018-19, 19-20, 2021, the council has not met 1,093. So when we get to the fifth paragraph dealing with the shortfall, which was supposed to be addressed by 2025, not only is the shortfall not being addressed, it's getting worse. Then, in terms of the second paragraph, the housing targets will be met through a combination of committed schemes, site allocation, and suitable windfall proposals. It's not between us and the council. I think it's agreed that the site is a windfall site, both in terms of the definition within the local plan and also within the definition of the NPPF. What you certainly need to come to a judgment on is, based on the evidence, whether this is a suitable windfall site. Then there's a question, sir, and then we move to the third paragraph, and this was, Miss Goodyear was taken to this by Mr. White. The majority of new housing development will be in Ashford and its periphery as the most sustainable location in borough, based on range of services, etc. That is correct. That's what's set out, and I agree with Miss Goodyear that how that has to be read is that is through the combination of committed schemes, site allocations, and windfalls, i.e. the overall package of requirements in terms of where housing is delivered. More than 50% of that needs to be delivered in Ashfield in order for that to be satisfied. But, sir, and if I may, can I take you to a document we haven't gone yet to, and it's the planning statement that was submitted with the planning application. I think it's CD 1.1, if I'm correct. And I want to go, sir, to table 6, page 43, sir. I believe. Let me see. Sorry, I'm also working. Yes. Right. Table 6.2, sir, at the bottom of page 43. Do you have that, sir? Yes. So as you can see, what Miss Ashworth, when submitting the planning application, she grappled with this position and realised the correct interpretation of what the policy says. And as you can see, what she did at the time of the submission of the application is she took the commitments and the allocations and everything else in terms of with the windfall figures, so the 3 components that I set out, and she's provided a breakdown of what would happen in terms of the overall distribution. As you can see, sir, what she has in the red, the first line, Ashford, 74.8%, and that includes extant commitments, allocations, etc., the total 74.8 would be in Ashford. That's based on the current strategy. And you can see, sir, that the impact of granting consent for 141 dwellings in Tenterden would have no impact realistically over the distribution of housing. It is not going to lead to a position where that 74.8 is going to reduce to 49%, and therefore the majority of housing is not going to be delivered in Ashford. And therefore I think it's fairly clear, sir, that the allegation made by the council that granting consent for 141 dwellings in Tenterden will not lead to any breach whatsoever of the requirement to provide the majority of housing development in Ashford and its periphery. So that deals with the third paragraph. Now, the fourth paragraph relates to development in the rural areas. And I think it's accepted we are in the rural area. Will be of a scale that is consistent with the relevant settlement accessibility, infrastructure provision, level of services available, suitability of sites, and environmental sustainability. And of course, you will have to come to a judgment on those matters. But when we talk about consistent with the relevant settlements, accessibility, infrastructure provision, etc., sir, we have to bear in mind that Tenterden is the second most sustainable settlement in Ashford Borough and the most sustainable settlement in the rural areas, i.e., if you are going to put development anywhere outside of Ashford, where you should be putting it is Tenterden as being the second most sustainable settlement. I accept it is totally and utterly different in terms of level of sustainability to Ashford. I am not going to make a case, and simply will not be correct of me to be making a case that Tenterden is as sustainable as Ashford, but it is not unsustainable. And we've heard from all the witnesses in terms of what, and you know, that was addressed by Mr. Marshall as to all the facilities that exist in Tenterden. And therefore, you know, if you are looking at anywhere to put development, if it's not at the most sustainable location in Ashford Borough, the next place you will be looking at is the second most sustainable, and that, sir, is Tenterden. And finally, I'm going to move on to paragraph 5, and therefore, sir, in relation to that, I don't see any breach at all of SB2 in relation to putting 141 dwellings in Tenterden. And then windfall housing development, I think this is where there is a matter between ourselves and the local authority. Windfall housing development will be permitted where it is consistent with the spatial strategy outlined above and is consistent with other policies of the local plan in order to ensure sustainable development is delivered. There are two elements to this. Totally, you have to meet both parts of it in order to be in compliance with it. You both have to be consistent with the spatial strategy outlined above, and it's not an or, so it's an and it has to be consistent with other policies of this local plan. Now, in terms of consistency with the spatial strategy outlined above, that is that the majority of housing development will be in Ashford. Well, I've already said so that will be complied with, because clearly it's not going to be the case, and I don't think it can be the case, that 141 dwellings will lead to the majority of housing not being in Ashford. That's all the requirements of the policy. So I think in terms of the first part of that, clearly granting consent for development would not breach that. As to whether it is consistent with other policies of the local plan, so that will be to your judgment based on the evidence that you have heard from the local council's witnesses and the appellant's witnesses, and also the matters raised by third parties. I'm not going to give evidence on that. That is not my role. I'm a planner. I'm not going to give evidence as to whether it is consistent. Clearly, in terms of our case, we believe it is consistent based on our evidence, but that will be a matter for you to come to a judgment on based on all the evidence. So that's in relation to that one. And finally, I just want to address the final point and kind of the final paragraph, which is to do with with the shortfall, because I think this does set out the context of where this local authority is going and really what it's thinking about and how it's looking to address this really important aspect of delivery of housing. Because what we have, sir, and you can see, because this does relate to the calculation of 5-year housing land supply. So while the first figure, if you recall, so the 13,118 at the beginning doesn't relate to 5-year housing land supply, the final figure, this paragraph does, because it clearly says, for the purpose of calculating 5-year housing land supply, the shortfall in housing delivery between 2011 and 2018 shall be rectified over a 7-year period to 352 dwellings per annum. So what we have here, sir, is when this plan was adopted, you had 8 years of shortfall, which equated to 352 dwellings per annum. And those were going to be covered, those were going to be addressed in the first 7 years of the plan. Now, I'm with Mr. White. My maths are absolutely awful. But 7 times 350, is that around 2,400 or thereabouts? So that was the shortfall when this plan was adopted. And that was supposed to be addressed by 2025. And that figure should be, as it says, added to the annualized ON requirement to provide an annual housing target of 1,240 dwellings plus any relevant buffer. I'm going to leave the buffer aside, sir. I think for my purpose, 1,240 is absolutely adequate. What this policy required is that the local authority in 2018, 19, 20, 2021, etc., will deliver a minimum of 1,240 dwellings. So you've got the figures. They're in the latest 5-year housing land supply statement. I'm not going to take you there. We've been through them. You know that in any of those years have we come anywhere close to 1,240 dwellings in terms of delivery. What that has in terms of consequence, other than the lack of the 5-year housing land supply, is that the housing position overall within Ashford Borough is not improving. It's getting worse. In order for it to improve, you would have had to have delivered every year over 1,240 dwellings, because this is addressing a shortfall back from 2011. So these are people, sir, who in 2011 needed houses, and yet 11 years later, the situation not only has not been addressed, but is getting worse. We're going to have a greater amount of shortfall added to the overall numbers rather than seeking to address them. I think that is quite important. That is a separate point to the 5-year housing land supply position, which we address with Mr. Taylor. This is whether this local plan and whether this policy is doing what it is supposed to do, which is, one, providing the overall requirement of 13,118 by 2030. The answer to that, sir, is unequivocally no. Then is the policy addressing the shortfall that's been around since 2011? And clearly, the answer to that is unequivocally no. Therefore, policy SP2, and firstly, as I've set out, I believe we fully comply with it. I can't see any breach in relation to it. But policy SP2, notwithstanding the position in terms of 5-year housing land supply, simply is not working whatsoever. Now, Ms. Goodyear said policy SP2 is working, and there are windfalls coming forward, and that would be able to address it. And in fact, she made a case that the windfalls should come forward in Ashford. And I don't disagree with her. I think, on the reading of the policy, the majority of windfalls should come forward in Ashford. But as you know, sir, because this is the council's evidence, in July 2020, Natural England wrote to the council saying they cannot grant planning permissions in Ashford unless there's a mitigation in place which some large sites, which we went to, so S2, for example, which we discussed, are able to provide mitigation on site, or there's going to have to be some kind of borough-wide mitigation, which we generally know in theory what Ashford Borough are going to do, but we have got no timetable. So how that's going to be delivered and when that's going to be delivered. But that has serious implications, because what that means, sir, is that you can't grant windfall consents. So since July 2020, no consents for small sites have been able to be granted in Ashford. And until the mitigation is in place, no windfalls will be able to be granted in Ashford. And Ms. Goodyear made the point that in relation to large sites, perhaps, you know, there were discussions about some of these allocations coming forward, and you could bring the applications forward, you can have discussions about reserve matters, and therefore, when the mitigation is in place, housing might come forward relatively quickly. Potentially in relation to large house builders who have got a huge amount of, you know, who can do that. But certainly in small windfalls, I simply cannot see how a local landowner or local house builder will be spending money to promote a planning application which they know won't be able to grant consent, with no knowledge whatsoever as to the cost of the mitigation. So what we have, sir, is a huge gap in terms of windfall delivery in Ashford, which is what Mr. Taylor said in his evidence. Because those won't be able, because there aren't consents, and because we've now got, well, a year and a half already of no consents in Ashford, and we don't know when they will be granted, that clearly has a wider knock-on effect. So when you look at SP2 and whether it is able to address both the overall local plan requirement and the shortfall, my answer and my point to you, sir, is it is totally and utterly failing.
Thank you, Mr. Ross. Right, let's then, can we please step on, can you come with me onto the balance, and let's first of all ask you about market housing and the weight. And I just want to ask you about, in the light of Miss Goodyear's evidence, what weight do you give to the provision of market housing and why?
Well, I think it's, well, I'm not going to go into the substantial significance kind of argument. In fact, I was reading overnight an appeal decision where, in fact, the inspector said that substantial is much higher than significant. I don't read that. I had at least half an hour cross-examination once. I think it was one of Mr. Howell Williams' colleagues, as to the difference between significant and substantial. But when you read the Oxford English Dictionary and go to the definition of what's substantial, it says significant. So I take Miss Goodyear's weighting as substantial, meaning significant, and I've set out my weighting. And I think in terms of market housing, we are in agreement that significant weight should be afforded to the provision of market housing for various reasons. One, obviously, there is a lack of housing land supply. Even on the council's case, there's a lack of housing land supply. But clearly, there also, the local plan itself is failing to deliver the market housing required. So that is why significant weight should be afforded to the provision of market housing.
Thank you. Next issue, then, can we move on to affordable housing?
Yes, we can.
Go on, carry on.
No, you ask your question, Mr. White.
What, in the light of Miss Goodyear's evidence, what weight do you give to the provision of affordable housing provided by this proposal?
Yeah. Okay. So I am going to start with a caveat, because as discussed by Mr. White and Mr. Howell Williams, and as obviously put to you in writing formally, the appellant is requesting that the appeal be determined on the basis of up to 141 dwellings. That will obviously have a knock-on effect in terms of the affordable housing. Now, in terms of the documentation before you in relation to the planning application, the proposal was that if 145 dwellings were provided, 72 of those were provided as affordable. That's what the proposal was set out, and that's in the documentation. If you accept, and obviously if you grant consent and if you accept the position in relation to 141, and I know, sir, you haven't seen the 106, so there's a lot of caveats here, but hopefully when you do get it, the way that the 106 is currently drafted, and I don't think this is between the parties, is that the provision of affordable housing would be 50% rounded up. That's the current wording in the 106. If I am wrong, and if it isn't further agreed, I'm sure I can be questioned about that. But I've looked at the latest version of the 106, and that's what it says. So if you do grant consent for 141, and if the reserve matters come up with 141, what that would mean, sir, and I really hope I've got my maths right here, that would mean 71 affordable homes. So the implication of the change between what was submitted in terms of the application and what the local authority determined the application on, and what is before you, sir, is one dwelling. And to my mind, that's not really material or significant in the overall balance. But what it does confirm, sir, is that the appellant is providing 50% of the units rounded up as affordable housing. Now, Mr. White took Ms. Goodyear to the affordable housing position, and you've seen the delivery of affordable housing position. I'd say it's lamentable, it's poor, whatever it is, it's nowhere near where it's supposed to be. But can I take you to policy HOU1 in the local plan, just again to be clear as to what the policy says? And
page 200.
Yes, I'm working on an electronic version, so it should come up. Here we go. So this is the local authority's policy in terms of the provision of affordable housing. And the council will require the provision of affordable housing on all schemes promoting 10 dwellings or more and on sites of 0.5 hectares or more, with provision being not less than the area-specific requirements set out in the following table. And all proposals are expected to meet their full affordable housing provision on site. Now, so can I go through this table, because I think it is important, because this, I think, is one of the reasons why delivery of affordable housing in Ashford is so poor. Because you can see there's 3 zones, can you see on the left, Zone A, Zone B, and Zone C. And Zone A is Ashford Town. And as you can see, sir, in Ashford Town, the total affordable housing required, the minimum, is only 20%. And then you go to the Ashford hinterlands, and that I think is the kind of what's considered the periphery, and there it's only 30%. And the rest of the borough, which includes Tenterden and the rural areas, it's 40%. So what you have is...
Can I just make a point? Sorry, Mr. Ross, to stop you in full flow, but just for the inspector's benefit, if you go back 2 pages to page 198, you see identified the zones fit geographically. So just for your benefit, you can see Zone A, Zone B, and Zone C. Sorry, I just thought so the inspector could get that context, Mr. Ross.
Yes, there's a plan set out, mapped to affordable housing viability areas. Now, I appreciate it's in relation to viability, and clearly what the local plan has done is assessed whether schemes would be viable to provide levels of affordable housing. And clearly in Ashford town centre, probably because house prices are not as high as other areas, you can only provide less affordable housing. And that's the point. So on one hand, the council is saying that the majority of delivery needs to be in Ashford and its periphery. where you can't provide, where there isn't a requirement to provide 40% affordable housing. Yet, as we know, the SHMA, which is an evidence-based document, certainly not a policy document, the SHMA, as I will say, Miss Goodyear was taken to yesterday, so the 2014 SHMA was, in fact, it should be 50% across the entirety of the borough. That's the real need. That's the need. Those are the people. That's the need in Ashford. If all schemes were viable, the policy would be that every scheme in Ashford Borough across the eye should be providing 50% affordable housing. Clearly, that's not possible. I totally appreciate that, but that is what the need was, and that is what the policy says. But it's worse than that, because if you look underneath the table, all proposals would be expected to meet their full affordable housing provision on site, except in the following circumstances. And then in Ashford town area, flatted development will not be required to provide any form of affordable housing. Well, I appreciate its viability. I totally understand why this policy is in place. But this is the reason why the affordable housing delivery in Ashford Borough is so lamentable and so poor. It's because the strategy of the council and where you are looking to deliver affordable housing is looking specifically to reduce the amount and cannot deliver the levels of affordable housing. Therefore, we are in a position where the provision of affordable housing and the way that the council is looking to meet affordable housing needs simply is not being met. Now, the reasons why I give more than significant weight, and I think it is important to differentiate between significant and more than significant, because I think this is an important matter that goes into the planning balance. The appellant could have provided 40% affordable housing, complied with the policy, and there would be no qualms between anybody that you still would have given significant weight to the provision of 40% affordable housing, given the affordable housing delivery. But what the appellant has done, sir, is is looking to provide 10% more affordable homes on this site. And therefore, the appellant must be given credit for going beyond what the policy says. And you know, I took in my evidence, and obviously this has not been rehearsed by Miss Goodyear, and I'm quite happy with that, that the council sought to introduce that the appellant providing 50% affordable housing was not in accordance with policy. But what it says here, that isn't what it says. It's a minimum requirement, not less than. So you meet policy by providing 40%, that is afforded significant weight. You go beyond the policy requirement, and that must be given greater weight, in my mind, in your determination when you consider whether to grant or not grant consent for this appeal.
Thank you. Right, can I then, just in the interest of time, can I then just please ask you the point was raised yesterday about whether you can cumulatively add up the benefits or not. And I just want to ask you, in the light of the benefits you've identified in your evidence, in the light of the evidence you've heard, what overall weighting do you give to the benefits in the balancing exercise, please, Mr. Ross?
Well, I must admit, Mr. White, I was a bit surprised by the approach of Miss Goodyear. And so I'll answer Mr. White's question first. I give it overall cumulatively significant weight to the benefits. But so if I may, I want to take you very quickly to two references. And these are the two recent appeal decisions that I have appeared for weight and the approach of the inspectors there. And can I please take you to, I think it's core document 6.8, sir, if I may.
That's right.
That the land to the east of Station Road Oakley, decision of Inspector Gilbert Woodridge of 11th of August 2021. And so if I can take you to paragraph 103, sir. And you will see, sir, where this comes. And if you go back, sir, if I take you to the top of page 18, you'll see it's main issue 7, planning balance. And he addresses the paragraph 11D. This is another case where there was an agreement between the parties. There was no 5-year housing land supply. And I think Mr. White took Miss Goodyear to the policies where reduced weight was afforded because of that to the spatial distribution strategies. And then he goes through the benefits. But you will see, sir, paragraph 103, and what he says, overall, the benefits of the development can be afforded significant weight. So what Mr. Gilbert Woodridge has done is exactly what I have done. He has looked at all the benefits, attribute some of them significant weight, some of them moderate weight, some of them more limited. And overall, he has concluded on the basis of that the benefits of the development can be afforded significant weight. And so can I also take...
Wait, Mr. Ross, before you move on, can I just ask you a question? Paragraph 106.
Yes.
First sentence, inspector there says the adverse impacts, notice the plural, can be afforded moderate weight. In your judgment, was the inspector in 106 cumulatively looking at the impacts or not?
Yes, of course. You have to do that. It's not one benefit outweighs one harm. It has to be done. You know, the wording, and you know, I'm happy to go to the NPPF, but when you look at it, and paragraph 11D of the NPPF, the adverse impacts would significantly and demonstrably outweigh the benefits. If you don't give a cumulative impact to the benefits, how can you make the judgment? So that's in relation to that decision. Can I very quickly, sir, take you to Court Document 6.9? So this is the appeal decision by Inspector Jordan. This is the land west of Winterfield Lane, East Malling, which I appeared at on behalf of Waiton, obviously is in Kent. And can I, sir, take you to paragraph 77? And again, you'll see it's under the planning balance. And again, you'll see the harm that would arise to landscape character of the area, taken together, loss of agricultural land, will not significantly and demonstrably outweigh. And then you've got the very substantial benefits. Clearly, and again, the scheme will provide in relation to housing provision and other identified benefits. So again, cumulatively, the inspector there has looked at all the benefits and come to a conclusion that the overall basket or package of benefits amounts to very substantial benefits. And therefore, I was surprised, and I struggled to see, sir, how you could come to a conclusion about the weight to be afforded to benefits and harm if you use Miss Goodyear's approach of not doing a cumulative assessment. And clearly that is endorsed by several inspectors, and that must be the right approach.
Before we leave that, Mr. Ross, can I just point out in para 69 and note the final sentence in para 69 of that decision there, the inspector attributed the provision of housing, including affordable housing, very substantial weight.
Yes, I mean, obviously each appeal is on its own case, and clearly, you know, the inspector there came to the conclusion that Tonbridge and Malling only had 2.2 years housing land supply, but you know, clearly that was the judgment that was open to come to the inspector at the time, and I think that was correct.
Right then, Mr. Ross, can we just then move on, please, to the other side of the balancing exercise, the harm, and just in the light of where we have got to on this day 8 of the inquiry, can I just ask you overall, can you just identify what points, having heard the evidence, you wish to make in relation to harm, and then overall, what weight do you give to the harm that constitutes the council's 7 reasons of refusal, please?
Well, you know, I've heard all the evidence that has been given. In terms of landscape, I afforded the harm to the landscape limited weight overall, and I think, you know, having heard the evidence, I continue to stand by that. I accept, you know, as Mr. Smith said, every greenfield site is going to have some harm, and I think Mr. Withergham, in his evidence, said, well, there might be a hugely degraded greenfield site on the edge of a very strong settlement that might not have harm, but we don't have one of those sites, and there's a need to address the housing requirement now. There's no other proposals before the local authority that I'm aware of in terms of addressing this shortfall, or any way of addressing this shortfall now. So, you know, I accept in some locations, as Mr. Smith said in his evidence, there will be some points where the harm would be significant, but overall, I think that the harm, given that the site is not in the area of outstanding natural beauty, will not have an impact on the A&B, will not have an impact on any designated landscape sites. That is correct. In terms of trees, I think the evidence in relation to T43, so that's the tree to be removed on Appledore Road. You know, clearly there's a difference between the parties, and the inspector will come to his own judgment in relation to that. But if I may, I do want to raise a point in relation to T381. And again, you know, Mr. Howell Williams, I'd be more than happy to be corrected in relation to this. And obviously it wasn't raised by any of the witnesses, but it was raised by the council in its original statement of case, that the development would, in relation to T381, would conflict with paragraph 180C of the NPPF. Now, so we haven't gone there because nobody's taken you there, because nobody's alleged before this inquiry that there would be harm, but that is in the written evidence before you. And that simply hasn't been an allegation of anybody, and that is an important consideration. If we do go to it, sir, so just that you have my evidence in relation to that, because as we know, the NPPF is a significant material consideration. That talks about development resulting in loss or deterioration of irreplaceable habitats, such as ancient woodland and ancient or veteran trees should be refused unless there are wholly exceptional reasons suitable compensation exists. Now, this obviously was a case, it was set out in the council statement of case, but I don't think, and I'm more than happy to be corrected on Mr. Howell Williams, that doesn't appear to be the case of the council now. And it's only in relation to tree 381 that seems to only relate to the local plan policies. And I think that must be right, sir, because if the council's case was that 180C was breached, if I may take you, sir, within the NPPF to footnote 7, and this is in relation to paragraph 11D. So this is on page 6 of the NPPF. And you will know, sir, that 11D1 sets out that the tilted balance wouldn't apply if there are clear reasons for refusal of development proposals. And that then relates to that footnote 7. And you will see, sir, that irreplaceable habitats is one of the points made that will disapply. Now, the council have clearly said, and Ms. Goodyear clearly said, that it's not the council's allegation that the tilted balance is disapplied, and therefore my understanding is therefore that this is not alleged by the council in relation to 381. I think that that's an important consideration for you. That was the original allegation. That's not the allegation anymore. And therefore, to my mind, that reduces, if there is any harm, and obviously in our case in relation to 381, you've got no evidence before you that there would be any loss or deterioration. Even if there is, there's no allegation of the breach in relation to that. Then very quickly, sir, on the other matters, we've obviously heard evidence in relation to ecology, and you'll obviously come to a judgment in relation to that. And then in relation to the public right of way, which clearly things have shifted slightly. The council now accept there's no breach of TRA 5 and only rely on the first policy. So I think when you look at what I've said in relation to the harm, not only do I think that the evidence provided fully supports that, I think that the council's case in relation to harm is potentially slightly weakened compared to the case that they set out in their statement of case.
Thank you. Could I then therefore bring it together, and can I just ask you overall, in the light of where we are, can you please tell the inspector what is your conclusion in relation to the development plan?
Well, sir, I think I'm clear that on the basis of the evidence of the appellant, the proposal complies with the provisions of the development plan, and I can't see any material considerations to indicate why a decision should not be made in accordance with the development plan. Indeed, my view is the material considerations indicate that permission should be granted.
Thank you. Can I then also deal with what your position is if the inspector doesn't agree, or what let's put the tilted balance into the mix. What do you say is the outcome of the tilted balance, please?
Well, my view is that cumulatively the weight to be afforded to the benefits is significant. Therefore, and that is a material consideration, significant and demonstrable harm has to be demonstrated to outweigh those significant benefits. And I don't think on the evidence that the inspector can come to a conclusion that such significant and demonstrable harm can be identified.
Thank you. Now, so in the light of the time, are you content? I mean, there are these series of 10, 11 questions from Miss Reed. I think my preference would be to complete the examination in chief now, or would you prefer me to deal with, to go through those 11 questions with Mr. Ross in chief and let him see if he can answer them? What would you prefer, sir? Sorry, sir, you're mute.
In terms of, well, I'm happy for him to just go through those questions. Mr. Ross, have you seen these questions?
I've seen them around 10 minutes before I start in my...
Yes, I've only just seen them, but they are related. They seem to be related to your proof of evidence. That's what. Yeah,
I mean, I'm happy to take them, sir, and I think, if I may, there are two or probably three comments also that I'd like to make in relation to other matters raised by third parties. You may recall, sir, when the third parties gave evidence on day one, that there were some questions that you may not remember, but I certainly did because I took note of them. Points that I wish to address in relation to points made by third parties. So perhaps I could go through the questions raised by Ms. Reed now. I'm certainly happy to do that now, sir, and then perhaps address 3 points that I don't think I've addressed in my evidence in relation to points made by third parties. Would that be okay to do that now, sir?
Yeah. I mean, when you're saying you're going to do it now, how long do you think you'll take to do it? That's all, because I'm aware that it's 11 o'clock.
5
now.
minutes. 5 minutes, sir.
Okay, then. Yeah. Thank you.
Well, let me address the third parties first, sir, because one of the points also addresses a comment made by Miss Reid. There was a point, if you remember, sir, and I think it was raised by Mr. Poole, about the electricity pylons, if you remember, the undergrounding of the electricity and the electricity supply. Do you remember that, sir?
Well, I was aware that was something was raised. Yes.
Yes.
I can't remember when it was raised or where it was raised, but it has been mentioned, I think, in written.
It is, and there was a point about delivery and approval of the Secretary of State for Education as well. And I think that this is also a point made, the last question made by Miss Reid. So in relation to the electricity, I just want to give you a note, so I don't have to take you there. CD 1.11 and section 4 of that addresses the matter of electricity. That's the utility statement, and that addresses that matter. In relation to delivery and approval of the Secretary of State for Education, I mean, I'm not a lawyer, so I can't definitively give an answer, but it is correct that the school is going to have to request permission from the Secretary of State to dispose of the two fields in its ownership. However, given that these playing fields have not been used, and given that Sport England have wholly agreed that they are not necessary anymore, I simply don't see this as being an issue that would affect delivery. It is a process to go through, but that is all. And once consent is granted, the process will commence, and I don't see it as being controversial whatsoever. So those were the points I think raised by Mr. Hall, and addresses one of the points raised by Miss Reid. Now, just very quickly, in terms of the questions raised by Miss Reid, in terms of the playing pitch, I just don't see the relevance of that. If it's 5 years or 10 years or 8 years, I simply don't see issues. Sport England have agreed in their consultation there's no need for the sports pitch. The school have written in and said they're not using it, so semantics. The second question I've already addressed, landscape character area is not a designation. Landscape character areas cover the whole of the country. Question 3 may be the case, totally irrelevant to us. It's not in the ARNB. There's no suggestion it will be. There's no proposal to review the high wheeled ARNB, so simply not relevant to us. Question 4, that's really a matter for the heritage witness. I'm simply not qualified to answer that. That's a heritage matter, and I'm not going to answer that question. That should have been put to the heritage witness. Question 5, simply not a matter. I mean, carbon calculation toolkits in relation to grassland and unploughed matters. I don't even know what Miss Reid is trying to get to, or what policy or what relevance that really has. We've provided our evidence in relation to the site and its sustainability, and that's agreed with the council. The sustainability of the site will meet and exceed building regulation requirements. Question 6 is the dormice point. Well, Mr. Goodwin's addressed that, so I'm not going there. Question 7, flooding has been addressed, sir. I'm not going to go there. Question 8, 50% of residents are lower income and live in affordable housing. I don't think that Miss Reid understands what affordable housing is. Affordable housing is there for people, key workers. Yes, they might be on lower incomes, but it's people like me who can't afford full market housing. And why will these people not contribute and spend in the local economy? I simply can't see any sense in that whatsoever. Question 9. Yes, I agree. Online shopping has affected matters. Absolutely, we you know that the increase in online shopping has led to changes in the high street. But that doesn't mean to say that people don't shop and people don't go to high street. And we've got a site that's very easily accessible to the high street. And as we know, Tenterden generally is doing quite well. Perhaps not as well as it did before, but still doing very well. So that's my answer to that. And I've addressed the issue of deliverability in question 10 already, sir. So I think that's my 5 minutes done in relation to the questions raised by Miss Reid.
Right. Thank you, Mr. Ross. I'll hand over to Mr. White again.
Well, just to say, so that completes Mr. Ross's examination in chief. Thank you very much.
Right. In that case, I'll look at having an adjournment of 15 minutes, and then Mr. Howell Williams will ask his questions. So I make it 10 past 11. So the inquiry is adjourned until 11:25.